Yes, good evening to the students of the SLW 600. Karibu sana. Welcome to my class. Anyone can unmute and read what I posted on the screen so that I could know that you are with me and I am with you. Both are sailing in the same boat to reach to the destination. Anyone? Haraka. Read
Welcome
what
to
I
the
posted on the
students.
screen.
Welcome
Proceed.
to the students of SLW 600 for virtual class on the 13th February 2023 from 4:45 p.m. to 5:40 p.m.
Tosha.
There is ritual rule, golden rule, mischief rule, purposive approach.
The judges use one of the four rules to work out what the statute means. Hosted by the Professor Dr. Mohammed Saheb Hussain, Professor of Law, School of Law, St. Augustine University of Tanzania, Mwanza, Tanzania, East Africa. Is it clear? Yes, we are
Yes.
dealing in my last class the golden rule and where we discussed the Varioba case law. And in the Varioba case law, if you make an offense in other items, bribery, that is a distinction. Either you do the bribery or illegal things, because both of the things are illegal things. And hence, mischief rule is applied over there. But in addition to that, also we have seen some of the English case laws where a mischief rule is used over there. And for instance, you take the person who got no, it's the alderman's case law, that is Stanford's alderman case law. A person should not supposed to marry when one of his wife is alive. It becomes a bigamy. So that case law says over there, if a person would like to marry when his or her spouse is alive to the second one, but he still did not marry it, but how he could become a bigamy? At that instant, they say the mischief rule will be used over there. When he is going to conduct the marriage, that is the meaning should have taken. When he is going to conduct the marriage, then it is amount to bigamy. Actually, such marriages are not a valid marriages, but when the wife is alive over there, and if you marry the second time, yes, it is amount to the bigamy. At that instance, mischief rule can be used over there. But somebody say, sir, it will not be a valid marriage, then how could it be a bigamy? No, the conducting a marriage itself is a act, but when the spouse is alive, it should be a bigamy. So that also case law in another things, English case law we study. I believe the Alderman versus Stent case law. If I not be mistaken, please check it in your other handouts. Yes, then let us see this. What is the advantages and disadvantages for this this golden rule? Yes. So, are you there?
Yes, Professor.
Okay. So, yes, advantage of the golden rule is it allows the judges to choose the most sensible meaning where there is a more than one meaning in the word in the act or statute that we discussed. And in my last class, I told you the plant. Plant means one is a bush or a botanical plant, another is a manufacturing unit. In the same way, I also gave the example of the issue. Issue means facts in issues, and another issue in the personal law is concerned issueless, Gumba, barren woman, and she doesn't have. So which meaning should be taken? So golden rule will be taken. It respects the words of the parliament except in a limited situation, the golden rule apply. When the actual literary meaning could be used over there, then it becomes a futile. At that instance, we can take the second meaning. And the third point is provides an escape route where there is a problem with using a literal meaning. When the problem would be there for the using the literal meaning at the time, we will deviate it and use the golden rule. And the next bullet is fourth is it can also provide a reasonable decisions. See, the literary meaning could be used over there. It gives the absurd results. But if you take the golden rule, a small deviation and the second meaning would be there, then it will be quite good. So that is the reason that he has said it can also provide a reasonable decisions in cases where the literary rule would lead to the rebuttment situation, bad situation. Yes, mute. And this goes for the wider meaning. And this is present in the Re-Sixworth case, in the case of the example. Of course, one of the examples which is giving, allowing the son of the benefit from his crime would have been unjust. I don't know whether you remember this case law, Re-Sixworth case law. If you happen to see the Re-Sixworth case law, in inheritance, especially in inheritance, for inherit the property of the father, in the will, I am speaking. When the will can be executed, anyone say? When the will can be executed, online people. No. Online people are there or not? Unmute and give me the answer.
Yes, we are there.
Give me the answer. When the will, W-I-L-L, will can be executed in the court of law. Saudi Kubwa. Keep the gadget near your mouth. Say, Pastor. What do you say, will in Kiswahili? Rusia. Osia. Tell me when the Osia can be implemented. Say, Pasan, if you don't know, why do you kill my time?
Pasa.
Why didn't you give the same answer in the beginning? Will can be executed. At that instance, a person who executed the will should have to die. Is it clear? Is it clear? The testator should have to die. Then only the will can be executed. Is it clear? Give me the answer.
Yes, please.
Yes. Good. Appreciate. Now mute it. So here in the Re-Sig case law, if you happen to see the case law, that is the Re-Sigworth case law, and a son killed the father because there is a will, and he want to get the father's property. Can he get the property? Samani. Can he get the property? Answer is no. Because his intention to kill him to get the property, and he is not going to get the property, he will be disinherited from the property. Because when the father is no more, then son would be entitled in the form of a will. But he intentionally killed him means, and at that instance, the golden rule could be used over there. The second meaning, inheritance. After the death of the father, death doesn't mean that he should be killed. Is it clear? Say yes.
Yes.
So now another bullet is a major advantage of the golden rule is that judge can be technically change the law by changing the meaning of the words in statutes. They can potentially infringe the separation of the powers between the legal and legislatures. So when the first meaning is taken, the absurd result at that instance, the judge will make a deviation to take the second meaning. Another main advantage of the golden rule is that drafting errors in status can be corrected immediately. And that is seen in the R versus Allen case where the loopholes were closed. The decision was in line with the Parliament's intention and gave more just outcomes. So when there is some loopholes would be there, not a technical word is used over there, but not a firm and constitute word is used over there. At that instance, a golden rule could be used to give a second meaning to give the justice to the parties. That is the advantage of it. Now let us see the disadvantage of the golden rule is there is no real guidelines as to when it can be used because there is no a clear-cut guidelines. Sometimes is arbitrary. So arbitrary leads to the not a proper way. So it's very limited in its use, and so it is only used in rare occasions, and it cannot be used. Only rare occasions can be used the golden rule, and it is not always possible to predict whether our courts will use the golden rule or not, because sometimes we cannot say that which rule could be applicable over there, and that is another criteria. And what seems to be the absurd in one judge may not be another to this means a case outcome is decided upon the judge rather than the law. I told you, no, a judge attitude, a judge thinking, it will be reflected in his judgment. So that's why that it is made very much clear that what seems to be absurd, no judge may not be another. So this means a case outcome is, the result of the outcome is decided based upon whom? Based upon the judges rather than the law. It is not based on the law, but it is based on the judges because they will give a second meaning but not follow the first meaning. So the golden rule won't help if there is no absurdity in the statute. For example, in case of the London and North Eastern Railway and Berryman, this is, I told you, that is greasing the lines. Greasing the lines, I told you. And there is no onlooked man at the upside and downside. But when he was greasing it, he was killed. But the law says the people, those who are maintenance work of railing and packing, at that instance, they will get the compensation, but not this man who is greasing it. And that is the point they said. Where the widow could not get the compensation because the literary rule used over there because the wording of the statute did not allow for these circumstances. The wording say maintenance. So in the maintenance, actually the greasing also comes under the maintenance. But they say maintenance means only keeping the sleepers and rails fixed to the sleepers and packing the sleepers. That is called maintenance. They give that meaning there. So that is the disadvantage we will find it. And of course there is a criticism also there. The golden rule is probably the most well-known ethical code of all the time. He was used by the Romans and Chinese, the Greeks, and adapted by every major religion imaginable. And at first glance, it does seems like a good ethical code to hold by the society. However, a golden rule is not only the flawed and selfish, but it can also justify the immoral acts also. Because it is not based on the law, it is based on a judge. So the main reason for the golden rule is flawed is because the moral standards and the criteria is not based on the desires and the preferences, and it is not even solely focused on what our preferences and desires are. The golden rule implies the basic assumptions and the other people would like to be treated the way that you would like to be treated. And with that, we are inevitably lead to the moral and relativism. Whatever your moral standards and desires are is what is normally morally good for others. The reason is the play of the judge is more because he will not take the first meaning, he will take the second meaning in the golden rule. In the second meaning, he will take it because of his whims and fancies or his school of thought. And in that way that he will deal it. That's why the criticism is there. So no such moral thinking can be counterproductive and used to justify the immoral acts. So naturally, a moral act will not become immoral because his aim is bad. No. Aim is good then naturally moral are also good. But eh, when the thinking is bad, then the attitude is bad. So that is the absurdity would be there. So they have made some criticism is there. The golden rule gives a court opportunity to create the exceptions given the public that are not based on the social subject but matter on the litigation, not even on the consequence of the wordings made by use of the lawmaking body, but entirely on the social and political perception of the judges and who deal with such a difficult cases. So it is merely based on the social and political, and it's the thinking of a judge, the golden rule lies. So in that way, there's a lot of criticism has come out in the golden rule. The same thing is mentioned here. Then we go to of course, these conclusions are different conclusions. Golden rule conclusions, these are all. So, golden rule conclusions, what we want to say here is the golden rule of interpretation could be concluded as if the language of the statute is clear, unambiguous, and ordinary, then the meaning should be in accordance with that only. Means golden rule cannot be used over there. Statute should be interpreted to materialize the intention of the legislature. What is the intention of the legislature would be there. In that way, the statute should be interpreted. Words leading to more than one meaning should always be understood in the meaning which is balanced and discretional. The second meaning would be balanced and discretional when the first meaning results the absurdity. So should avoid and prevent the inconsistency and inconvenience result. Because whenever the meaning is taken, that it should not give the inconsistency or inconvenient results over there. Then such interpretation should be avoided and result that directly causing the injustice. At the time, the golden rule cannot be used over there. So meaningless and illogical interpretation should not be accepted. If a meaning is there, a meaningless or illogical interpretation, it should be not be used over there. So the language of the statute is not clear. When the language of the statute is not clear and lead to the more than one meaning not showing the intention of the legislator, then the language used in the statute should be reformed and other rules of interpretation can be used for the help. And this is the golden rule of interpretation. See, the golden rule of interpretation can be used at that instance when the first meaning leads to the haphazard results, inconsistency, or it is fructuous. At that instant, the second rule can be used over there. I mean, second meaning can be used over there to give the justice to the party. But when you're using the second meaning, again, is the judge make the fancies. He can have his own right. Because the second meaning is not based on the law. It is based on the judge. And a common law applicable. Like the example, plant and issues, which I have given. So every rule having its own advantages and disadvantages, but the judge will see that which theory could be good to give the justice to these parties depending upon the facts and depending upon the nature of the case and depending upon the statute, and they will decide it. Either the literary rule should be used, or the golden rule should be used, or the Mischcief rule should be used, or the purposive rule should be used. But overall, he wants to see that the person who comes to the court should not go with the empty hands. See, there is another meaning also there. So now the next is Mischcief rule. So Mischcief rule is the rule of statutory interpretation which tries to interpret the statutory words by looking at the intention of the parliament through the history of the enactment of the particular act. When any act is made, it is made because of the necessity. Because of the cases to come up to resolve such cases, so act could be passed. Like Law of Marriage Act is passed because there is no strict which type of the marriage is married marriage, which not marriage. There is a lot of disturbance would be there, and tussle would be there, confusion would be there, conflict would be there, disputes would be there. Hence, to avoid all those things, Law of Marriage Act is passed. Yes, these type of the marriages are valid marriages. So no dispute would be there now because it is already codified. So when you are codifying it, the intention of the people, a man and a woman would be treated as a wife and husband, and there is a legal tie. And the people should not say that it is a union. So that's why the purpose of it is taken into consideration. So when applying this rule, the court should ask itself what mischief was intended to be cured by this provision. Suppose if a court wants to use the mischief rule, it will see that what something lacunae is there, where the common law, he did not address it. That's why 4 points should be come out in this way. So this is sometimes called the rule of Haydn's. It's the Haydn's made it such a case, and the Haydn's rule also we can say. So when you say the Haydn's case court rules that show the true interpretation of all statutes, the 4 things must be considered. Number 1, what was the common law before the statute was made? How the common law is there, and before this statute is made, a particular statute is made. And second, what were the mischief and defect for which the common law did not provide? At that instance, what is the defect would be there, mischief would be there, where a common law will not provide, and this act is emerged. And this act is emerged to prevent such a defect. Number 3, what remedy has the parliament appointed to cure the disease of the commonwealth? So, common law will not give any remedy. At that instance, a new act is made. Now you tell me what the new act is going to give the relief. The new act which is enacted is going to give the relief as another point. And the 4th point is the true reason for the remedy. What is the true reason for the remedy? We have to see it. So when you address these 4 points, then what should be used, you should have to come out. And you do have an idea. And in the last class I say prostitutions. The prostitution is not the golden rule, it is a mischief rule. That is a Huck's case law. Yes, we will study in this class. The judges of the exchequer stated further that it is the role of the judges to make a construction that will suppress the subtle invention of the continuing the mischief to add force and life to the remedy according to the true intention of the makers of the act. What is the true intention of the makers of the act would be there. And that meaning should be used over there because the act is enacted to curb such a evil, or such a vice, such a defect, such a thing which is contrary to the society. So, mischief rule has significantly influenced the interpretation of statutes that take into consideration of the historical background of the particular act. So, when an act would be taken or enacted, we have to see the historical background, why this enactment is enacted, what is the purpose behind them. So, like Michael Zander says, what he says, the mischief rule is designated to get the court to consider why the act was passed and to apply that judge is giving the words and the consideration, whatever the meaning will best accord with the social purpose of the legislation. So now let us examine or define it or explain the mischief rule of the Zander. Michael Zander. Michael Zander says the mischief rule is made to get the court to reconsider. What reconsider? Where a common law failed and the new law is passed, and the new law is going to give the remedy or not. If the new law is not going to give the remedy at the time, we have to give a better remedy by applying the judge's thinking and intention and how it would be. So these are the things will be observed. So the court will consider why the act was passed and why, and then to apply the knowledge in giving the words under the consideration, whatever meaning it will best accord with the special purpose of the legislation. Suppose the legislation would not cover a particular aspect of it, but the act is made because of that reason, then the wider meaning can be given over there. So depending upon the situation, mischief can be used. So now let us go a bit further. The court observed to the meaning of the rule. Under this rule, the court, in looking for the true meaning of the ambiguous statutory provisions, is guided by the defect or mischief which the statute was enacted to rectify or cure. If any statute will be enacted, it is enacted to rectify a particular thing, to cure a particular thing. That is the intention of the statute. Is it clear? And here, I don't know whether you remember it, the case law. B. Hawa Muhammad versus Ali Saif. You read the case law. See, if you happen to see the services made by the housewife, also contribution for the matrimonial property. But in this case law, they have not taken. In this case law, they have not taken in that way. Why they have not taken, they give the reason also. I think the Ramadani has given the judgment. If it not be Justice Ramadani. Yes, because I remember, because when I taught in the UDSM, I could remember the case law. Why it is not given, the reason they are told. This lady spends a lot of amount and given by the husband to take care of the house, and she is mesa, she used to eat it. So the court observed, even the taking care of the children, and moreover, I don't think that they are the children are there. Or if they are there, I think one or two are not taking care of her, and she is never taking care of it. And that's why the court decided that his contribution is zero. And hence, the mischief rule can be applied over there, and she is not entitled to get the anything from it. But later on the cases, they give the different judgments, because even the taking care of the family and taking care of the husband, taking care of the house, it is also a contribution economically. And hence, whatever the property is gained in the matrimonial tie is there, that is a common property. And the equal share would be there. Not I am speaking under the self-acquired property. And before marriage. No. So, this is a very controversial case law, that is, and where the judgment is given, but here he could not succeed it because of various other reasons. Here the mischief rule is used over here. And that is a very, very wonderful case law. You read it. And another case law that I made it, of course there are other case laws also there, but I told you the prostitution case law, is it not? Prostitution case law. So in the prostitution, again I made the small Bibi Hawa case law also. But in another case law, they have given the equal property. And that case law is Hamid Abdul versus Ramadani Mokaje. In that case law, the Bahati, he has given, Judge Bahati. The Judge Bahati said, not Bahati. Bahati means roof, that is corrugated tins, Singida. This Bahati accepted the principle that domestic services are valuable contribution to the property acquisition, but refuted the entitlement to an equal share in such property where the wife main contribution in the form of domestic service. It depends upon whether she use it in a permanent way or in a good way or not, but in general, they contributed to the economy, even though she is not an employee, but by taking care of the family and children and cooking and etc. And this mischief rule could be applied here again. I told you the Smith versus Hutch case law, not the golden rule it is. If I say the golden rules, I take back my words. It is the Smith versus Hutch. Can anyone unmute and read this case law? Can anyone unmute and read this case law?
Yes, sir.
Proceed.
Which case law?
Which I highlighted.
In Smith versus Hughes, 1960, the defendants were charged under the Street Offences Act 1959 with soliciting in a public place The prostitutes were soliciting from windows, technical, not a public place. The mischief rule was applied to interpret the prostitutes were doing what the statute was trying to abolish. So they were convicted.
Yes. I told you in my earlier classes, in Sherbaro language, prostitute, Malaya. In Sherbaro language, what do you say in Kingereza?
Kiingereza,
Yes. Prostitute.
Sharima, prostitute.
In Sherbaro
What is
language,
English?
what do you say prostitute? In Kingereza?
Muhuni. Muhuni.
No. I say Kingereza.
I don't know Kiingereza.
Harlot.
Mm.
Harlot.
Oh, okay.
That is number one meaning. Another meaning is war. W-H-O-R-E. W-H-O-R-E. War. It is a Sherbaro language. Instead of saying the Malaya prostitute, we can say harlot or war. In this case law, a act is passed. What is that act? Street Offences Act. 1951. Shall I close this one? Okay. So, but you close it, no matter. The Street Offences Act, that is already closed. The Street Offences Act, the purpose of making this act, the prostitution should not attract the customers. That is actually the intention of the making this act, Street Offences Act. And these prostitutes, Malaya, wore, harlot, not standing on the street, but they're standing on their balcony, they're standing at their windows, they're standing at the doors in their own house. From there, they are attracting the people, those who are passing, for getting their customers. That is the body-to-body contact. So the government filed a case against the prostitute. Do you know the prostitutes, what the harlot defendant taken? We are not inviting the people by standing on the street. We are inviting the people by standing in our own houses. Either you are standing on the own houses or standing on the branch of a tree. Doesn't make any difference, because you are doing the same act of attracting the people for the sex. The intention of making this act is you are inviting them to have the sex with you and getting the money, and hence mischief rule can be applied. So mischief rule was applied to interpret that the prostitutes were doing what the statute was trying to abolish. So they were convicted. The intention of the legislature is they should not attract the passengers. Passerbys. That is the intention. Either by standing on the road or by standing in your own house or standing on the tree, by claiming on the tree also. Is it clear? Say yes. Smith versus Hutch case law and the purpose of the act, they made it very much clear, and hence a mischief rule could be used by following the Hayden's rule. What would be the remedy? The remedy is you can stand anywhere, but the purpose is the same. You are attracting the customers. So that's why they extended it to it. Wherever you stand doesn't make any difference, but you are doing the same act. and hence mischief rule can be applied. Now let us see the purposive approach rule. The purposive approach rule is the rule of statutory interpretation that intensifies the overall purpose of the legislation. It is frequently used in the combination with the golden rule. Of course, 5 minutes are left, or the mischief rule. Combination of it both. It is sometimes called the teleological approach and rule, different from the mischief or golden rule, in discerning such an intention with a purposive purpose. What is the purpose of making such a thing? That is more important in this rule. Frequently, reference may be made to the more recent events so as to produce the intention that relate to all the cognate provisions of the law currently in force. The aim is to update the intention of the Parliament with the prevailing circumstances. The purposive approach, statutory approach, the interpretation is take the quiz on the statutory interpretation, play the statutory interpretation, arcade game, of course, these are all different factors are there, how the statutory interpretation will make it concern. But when you closely watch this purposive approach and statutory interpretation in the European court or in the court of any other country, the domestic judges are required to apply the purposive approach whenever they're applying the piece of the EU law or any law. For instance, take Mounsell versus Olnis. That is the case law. Case summary is the fact task of the court of construction is to put itself the shoes of the draftsman to consider what knowledge he had and importantly what statutory object he had. Being thus placed, the court proceed to ascertain the meaning of the statutory language. Why the Parliament made such an act? What is the purpose of it? And that correct exact purpose should be taken. The purposive approach to statutory interpretation seeks to look for the purpose of the legislation before interpreting the words. It is often been said that the purposive approach is a mixture of the domestic rules. However, whereas the domestic rules require the court to apply the literary rule first to look at the wording of the act, then the purposive approach starts with the mischief rule in seeking the purpose of the intention of the Parliament. Either use any rule, either literary rule, golden rule, mischief rule, purpose. When you come to the purpose, what is the purpose of the legislature to pass such an act? That is more important. If that is more important, then we know. For example, here given in relaxing the rule and the reference to the Hansard in Pepper versus Hart case law. Hansard in Pepper versus Hart case law, it is given the courts are required to apply the purposive approach when interpreting the EU law. The court have used it when it interpreting the domestic legislation to give an interpretation in the line of the EU law. For example, see Pickstone versus Freeman PLC. The purposive approach has been highly influential and judges have applied it when interpreting the domestic legislation which has no connection with the EU law. Why the court or the Parliament uses such a law? Like Smith versus Sachs, the Parliament used such a law to curb the mischief of these Malayas, prostitutes, harlots. And that is the purpose of it. If you see the purpose of it, either they are standing on the street, they are climbing on the tree, or they are standing in their balcony, or they are standing in their house, doesn't make. The purpose is the same. Attracting the customers. So, attracting the customers, they are making the purpose. The members have made such a thing, the purpose of them to stop such a attraction by the harlots. That is the main purpose of it. So, the purposive rule means with that purpose the enactment is made. You can use any law, literary rule, golden rule, mischief rule, any rule. But the purpose of the law is that factor. And hence, you are not supposed to do. And the purpose of the law not to hurt anybody. Either you are bitten by your teeth or made the cut with the instrument or wound by the instrument, doesn't matter whether he got the injured or not. When he got the injured, he should be punished. And who caused the injury? That is the purpose of it. So we could not use whether he used the instrument or not, whether he used it, whether he is lining or not, greasing or not, but he is also working on the rails, and hence he should be given. So the purpose rule is there. they did not see all these things and the see what the intention of the parliamentary is there, and hence they should be given the compensation. In the railway track rule, compensation should be paid. In the bitten case knows, the compensation should be paid.
So I spend a lot of time working on social media for my clients. I create a lot of video content